We're here, it's the final lecture on mortgages. In the last couple of lectures we've obviously talked about the rights of the mortgagor and the rights of the mortgagee. And so in this last lecture we're going to focus on the remedies that are available. Now in most mortgage situations it's the mortgagor or the homeowner who has not repaid the mortgage, and so the bank or the mortgagee is trying to get their money back. So most of the remedies that we're going to be looking at today will be seeking to help out the mortgagee, but that doesn't mean that the mortgagor is left high and dry with no recourse for action. There are certain protections that exist in place when the bank is trying to take their home, and so we'll try and keep that balance in mind and focus on that as we progress through this lecture. Right, let's get started. So all I've done on this first slide is to list the various remedies that are available and that we are going to be going through today. So we'll start with the first one, which is this personal covenant to pay the mortgage. So even if the bank takes over a property, there's still an obligation to repay the debt. And to a great extent, this makes a lot of sense. When you take out a mortgage on a particular property, you're basically asking the bank to borrow a certain amount of money. And so in return, the bank wants that money back with interest on top. They're not especially interested in the property per se as getting the money back that they have lent you. So I've put an example there, and this obligation to repay the personal covenant comes from the case of Rudge and Richens in 1873. Moving on, we have the appointment of a receiver, which is another advantage that a mortgagee can have, and this becomes available to the mortgagee when the mortgage money is due. Basically, the duty of the receiver is to try and bring about a type of situation whereby the debt can be paid. In other words, helping the mortgagee to get that money back. Now, the receiver, interestingly, is technically an agent of the mortgagor rather than the mortgagee. And this is a huge advantage for the mortgagee because any liability or any duty the mortgagor is ultimately liable for. And this was seen in the case of White and Metcalf in 1903. But the advantage to the mortgagee in appointing a receiver actually goes further than this, because the mortgagee can direct the receiver's actions even though it is the mortgagor who is responsible. This was seen in American Express and Hurley in 1985. And furthermore, despite that link between the mortgagor and the receiver still owes the mortgagee a fiduciary duty. And we can see the case of Medforth and Blake, which sets out some of those fiduciary duties in much detail, so you can go and look at that case if you want to find out more. And also the case of Silven Properties in RBS talks about those self-same duties as well. So right to possession is not normally existing on itself. The mortgagee is not really interested in possessing the property per se. They just seek the right to possession before going on to sell the property. So the courts do have an extensive power to postpone, but as per section 36 of the Administration of Justice Act 1970, this power only exists when the mortgagee brings an action. And this particular wording came under scrutiny in the case of Ropaigealach, I've probably pronounced that horribly, but never mind, and Barclays Bank in 2000. In this situation, the bank didn't actually bring an action as per the 1970 Act. They just issued a notice to the mortgagor, and the mortgagor was on holiday at the time. They came back from their holiday, and the bank had just basically gone ahead and sold the property. And they just found out from a neighbour that their house that they lived in had just been sold. So obviously they tried to sort of bring this case before court, and they said that the court should have been able to postpone the action. But the wording is pretty clear, and so the judges were not really in a position to do anything. The bank hadn't brought an action, and so section 36 of the Administration of Justice Act did not apply. This might be particularly interesting if you are doing an essay on this topic, because it raises certain human rights concerns. Obviously, in the Ropaigealach case, we have a family who's basically come home from holiday and they've been kicked out of their house. So there's obvious issues around particularly Article 8, which is right to private and family life, and also questions surrounding the legal process that's involved there. So there might be questions around Article 6 and the right to due process. Nevertheless, in such a situation where the right to possession is exercised by the mortgagee, they have to provide information to the mortgagor before taking that. And that comes from the FCA handbook, which we did mention a little bit in the last lecture. It's not really a sort of statutory authority, but nevertheless, the rules still do apply to mortgagees in these types of situations. And when we're looking at that information to do with the possession, they have to set out the default that is owed by the mortgagor. Also, other things like whether the mortgagor who's potentially going to lose their home, whether they are able to claim housing from the local authority so they don't end up being homeless, and different things like that, just to make sure that they're not left out on the streets and they are fully informed of what is going on. So the courts can grant the short-term stay of possession proceedings. This was particularly seen in Rudge Benefit Building Society and Roberts. In that case, the judge talked about sort of protecting the lamb from the wind. And another judge later on, Master Ball, talked about he felt more like a social worker than a judge when he was sort of exercising this discretion. However, it is less liberally applied nowadays, as seen in the case of Birmingham Citizens Permanent Building Society in Quant. In other words, the judges and the courts are less likely to get in the way of a mortgagee's right to possession. So we've already talked a little bit about Section 36 of the Administration of Justice Act and in relation to it being bringing in action. But the details of this are worth going into because obviously it is available in most situations where the bank does bring in action. And so the mortgagor is not required to pay the entire debt. It's obviously only just sort of the bit that they owe. So it's not like there's a huge liability involved. But even though they might only be paying a small part of the mortgage debt, there does still have to be shown that there is an ability to pay that debt. So showing that the person is earning money and that they will be able to pay back the money. Otherwise, it's not worth postponing the possession and eventual sale of the property. The courts can postpone it for a period of time, but they can't do so indefinitely. There might be a suspension allowed to allow for a privately negotiated sale. And finally, those with home rights in the property, so a person's wife or husband or partner or children, must also be served notice of an action for possession as well. So that's quite an important rule in place under Section 36 and how that piece of statute law has developed over the years. So on top of the power of possession, we have the power of sale, and there's a distinction that's made in this type of case law and statute law in particular. The distinction is between, on the one hand, where the power of sale arises, in other words, when it becomes available, and when it can actually be exercised by the mortgagee. So first of all, the power arises where these three conditions are all met. So the mortgage has been affected by a deed, the mortgage money has become due, and the mortgage agreement allows for the power of sale. So when those conditions are met, the power of sale is said to arise, and it becomes exercisable. In other words, the bank can carry it out when one of the following three conditions has been met. So either the mortgagor has been in default for 3 months after notice for payment, interest is unpaid 2 months after being due, or there's a breach of another mortgage term aside from that money or interest issue that we talked about in the first couple. So one of those, and then the power of sale does become exercisable. So we'll go ahead and we'll say that in a type of situation, the property has actually been sold by the mortgagee. And when this happens, the proceeds are applied in a particular order. So first things first is paying the costs, charges, expenses that arise because of the sale. So for example, the solicitor's fees, the estate agent's fees, stamp duty, that sort of thing. So that's the first thing to get out of the way because that's associated with the sale directly. Only then after that do we actually try and discharge the mortgage and the associated interest and costs. If there's money left after that, then it goes to payment of other mortgagees or other chargees over the property. And then if there is any remaining money after that, which is normally unlikely, that does actually go back to the mortgagor themselves. So any excess money left afterwards does go into the mortgagor's pocket. So when the mortgagee actually undertakes to sell a particular property, they do have a duty to the mortgagor, and that exists in two parts. There's a subjective element, which is they have to act in good faith, and the mortgagee also has a duty of reasonable care. And so you see this subjective and objective element to a test. The subjective duty itself is actually relatively straightforward and basically means that the mortgagee should not act in a reckless fashion. This was seen in the case of Kennedy and de Trafford in 1897. But the most common example where the subjective test fails is where there is a conflict of interest. So in this case of Martinson and Clowers, the mortgagee sold the property, but he sold it to himself, and so there was a clear conflict of interest. Similar situation might arise where they sell it to a family member or a company where they're a shareholder, basically wherever there is a clear conflict of interest at stake. The objective duty is a little bit more complicated, but we'll just go through it now. Basically, the mortgagee has to sell the property as if it were being sold on the open market by a willing vendor, as per the Housing Act 1985. So to give you an example, we could say that objectively a house might be worth £250,000. Now, if the mortgagee sold that on the open market for £245,000, well, I think that we could objectively account for that sort of £5,000 differential because of fluctuations in the market and things like that. However, if the £250,000 house was sold for £100,000, I think that we could say that objectively this is not close to the reasonable value that we would objectively see for that particular property. And so the mortgagee would have failed in his duty in that particular circumstance. The other objective duty requires the property to be taken to market as soon as possible. Again, we can look to the FCA handbook for that. This is potentially a little bit controversial if you think about it, because you can imagine situations such as where there was the housing crash, where properties would have been worth a lot of money before the housing crash happened, and then they were worth not very much afterwards. And so we have a situation where the price fluctuation for the property is very different, and there might be actually some benefit to waiting a little bit. But nevertheless, the mortgagee has every right to try and recover the money as soon as they possibly can, and they should not delay that or try and speed things up too quickly just to try and make more money. They should just basically try and sell the property as soon as possible. So what happens when something goes wrong with the sale of the property? Well, the court can set the sale aside, as in the case that I'm not going to even try and pronounce there. But this really only happens in cases of fraud. What realistically happens in most cases where there's been a problem with the sale is that there is liability to account. And this was seen in the case of artistic builders. And there's an example at the bottom of the slide there that you can see. So we've got a homeowner who owes £50,000 to the bank, but the mortgagee undersells the property by £30,000. So rather than sort of trying to work that out, they basically split the difference and say, well, actually then the homeowner's remaining liability is £20,000. The existing liability of £50,000 minus the mistake by the sale of the property for a lower price. Finally, the last remedy that we have is foreclosure. This is very rare nowadays because it is so draconian. It leaves the entire value of the property in the hands of the mortgagee, but importantly it removes the equity of redemption. And you'll remember in the first part of our lecture series on mortgages we talked about the importance that's placed on that equity of redemption for the mortgagor. And so the idea of foreclosure is relatively rare nowadays, because it does remove that important equity of redemption. It can only be used when the legal right to redemption has been extinguished. Moving on, we can see the two-part procedure that exists for this. And the first stage is an order for foreclosure nisi, which is made by the High Court, basically saying that the money has to be paid within a certain period, and usually that is 6 months. Then, after the 6 months, if the payment hasn't been made, the court makes an order for foreclosure absolute, which transfers the estate from the mortgagor to the mortgagee, and that completes the foreclosure procedure. Now, it is draconian, but there are some remedies that are available through this procedure for the mortgagor. In particular, before that foreclosure absolute, the mortgagor can request the sale instead. And then after the foreclosure absolute, the order can still potentially be reopened. So there is that option that is available. And that completes mortgages. Well done for making it this far. If you do answer mortgages in a problem question or maybe even an essay question as well, please make sure that you do talk about the remedies that are available. It's easy marks to pick up at the end of an exam or a coursework, and it's not too difficult to get a grasp of. Obviously, the main focus is on remedies for mortgagees, but you do also want to think about what protection is available for mortgagors who, let's remember, are potentially going to be losing their house as a result of this process. Well, I hope you enjoyed this video. If you did, make sure to leave it a like and subscribe for more videos in the future. Also, if you've got any questions or comments, leave those in the comment box below and I'll try and get back to you. Thanks very much for watching. Bye!